Missed FBAR filing, the Streamlined program may not save you anymore. Think the IRS Streamlined program will bail you out if you missed an FBAR filing. Most people do, but the IRS is now disqualifying more applicants than ever. If they find you first, the penalty can be 50% of your highest account balance every year for every account. Before we dive in, if you have unfiled FBARs right now, call us at 855-900-1040 or visit silvertaxgroup.com for a confidential case review. We'll tell you exactly where you stand. You can also reach us through our 24-hour live chat. Don't wait until the IRS comes knocking at your door. Call now for help. I'm tax attorney Chad Silver, founder of Silver Tax Group. For over 20 years, my firm has helped clients nationwide navigate FBAR compliance, offshore reporting, and IRS enforcement. We build your compliance strategy, we implement it, and we'll defend it if necessary. Today, I'm covering what the Streamlined program actually requires, why the IRS is challenging more non-willful claims than ever, and what your real options are if you've missed FBAR filings. Section 1, what the Streamlined program actually is and what it isn't. The IRS Streamlined filing compliance procedures were designed for one specific taxpayer, someone who missed FBAR filings due to non-willful conduct. That means you didn't know you had to file or you misunderstood the rules, not that you knew and you chose to ignore it. If you qualify, the penalties drop dramatically. For U.S. residents, there's a 5% miscellaneous offshore penalty. For expats abroad using the streamlined foreign offshore procedures, there is no penalty at all, zero penalty. That sounds like a clean exit, but here's the problem. The eligibility bar is getting harder to clear every year. Section 2, why the IRS is disqualifying more applicants than ever. The biggest issue is willfulness. To use the Streamlined program, you have to certify in writing that your failure to file was non-willful. That's a legal certification, and the IRS is scrutinizing those certifications more aggressively than ever. Here's what gets people disqualified. If you check no on Schedule B of your 1040 tax return even once, when asked whether you had a foreign account, the IRS can use that as evidence of willfulness. If you receive bank statements from a foreign account and didn't report them, that's also evidence. If you worked with an accountant who should have flagged it, the IRS may argue you had constructive knowledge. The IRS uses your tax return historically to build a willfulness case, even if you never intended to hide anything. And then there's timing. If the IRS has already opened a civil examination or a criminal investigation, even one you don't know about yet, you are no longer eligible for the Streamlined program. That door, unfortunately, has closed permanently. The bottom line, the Streamlined program is powerful, but it's not a guaranteed safety net, and it's not something you can self-apply your way through without legal guidance. Anything I've just covered sounds familiar to your situation. Call us now at 855-900-1040 or visit silvertaxgroup.com. The earlier you come to us, the more options you have. That's not a sales pitch. That's just how the IRS enforcement works. The window doesn't stay open forever. Section 3, a real example. I recently worked with a client, I'll call him David, a dual citizen living in Canada with foreign accounts going back 12 years. He'd found the Streamlined program online and was ready to self-file. He'd even written his non-willful certification. But when we reviewed his 1040 history, he checked no on the foreign account question for 3 consecutive years. That single mistake would have torpedoed his Streamlined eligibility and potentially opened him up to a willfulness finding. Instead, we submitted through the Delinquent FBAR submission procedures, built a strong reasonable cause argument, and eliminated his penalty exposure entirely. David walked away totally clean. The lesson we learned from this is the program that looks like the right answer isn't always the right answer, and that's why you need a legal strategy, not just a form. Section 4, what your options actually are. If you've missed FBAR filings, you have more paths than just the Streamlined program. The Streamlined domestic offshore procedures for U.S. residents with non-willful violations, 5% penalty, requires a certified non-willful statement. The streamlined offshore procedures for expats living outside the U.S. have zero penalty, same non-willful requirement. The delinquent FBAR submission procedures for people with reasonable cause for non-filing who aren't under examination, there's no automatic penalty. And this was David's path. The IRS Voluntary Disclosure Program for willful violations. This protects you from criminal charges while resolving the civil penalties. It's not cheap, but it keeps you out of court. Penalty defenses and appeals. If you've already been assessed, we can fight back. Reasonable cause arguments, first-time penalty abatement, and statute of limitations defenses all have a role in these cases. The right path depends on your specific facts, and the difference between paths can be hundreds or thousands of dollars. If you have unfiled FBARs, unreported foreign accounts, or you're not really sure which program fits your situation, don't guess. Call Silver Tax Group at 855-900-1040 or visit silvertaxgroup.com. We'll give you a confidential review, tell you exactly where you stand, and we'll build a strategy to fix it. At Silver Tax Group, we build your compliance strategy, we implement it, and we'll defend it if necessary before the IRS. Don't wait until the IRS comes knocking at your door. I'm tax attorney Chad Silver. Click subscribe so you don't miss the next one. Thank you very much.